This is the Citi Newsroom. Now, it's been almost a month since Ghanaians went to the polls on December 7th. Now, in the aftermath of that exercise, there have been a number of court cases. Now, in today's edition of the Citi Newsroom, we will be putting the spotlight on two of such court cases. Now, in the Supreme Court, we have the state challenging the injunction placed on the swearing-in of the MP-elect for the Hohoe constituency, John Peter Amewu, and also in the Circuit Court, we have a case brought by the state against 20 MPs that marched onto the Electoral Commission to present a petition against the parliamentary polls as well as the presidential polls, specifically the polls in Techiman South constituency. My name is Bobby Osei, and you're welcome to the Citi Newsroom. So after 4 hours of proceedings at the Supreme Court, representatives, including lawyers of various parties to the case involving the state challenging the injunction placed by the Hohoe High Court on MP-elect for Hohoe, John Peter Amewu, have all stepped out of the courtroom. Now, they are joined or followed by their various entourages. Now, we did try to get interviews with the various parties, including Chachu Chikata, who represents a resident of Sancho, Kofi, Akpafu, Likpe, and Lulubi. We also tried to engage with Deputy Attorney General Godfred Dami, who is leading the case for the state. He also said he will not speak, but will wait for judgment on the 5th of January. We did, however, catch up with the General Secretary of the New Patriotic Party, and he essentially had some words to share with us, as he believes that he is a stakeholder to this particular case.
I'm an interested party. I'm the General Secretary for the New Patriotic Party, and if there is any court action that is likely to affect my legally elected parliamentary candidate elect representing Hohoe constituency, I must be interested, and I am interested.
But you, as a party, did not seem to take interest in this when it started.
The person went as party. They went as party. How will I know that people are conspiring to deny a legally elected member of parliament his right to represent Hohoe constituency? How am I going to know?
So today, the Apex Court of the land saw a Deputy Attorney General, Godfred Dami, continuing with their calls for the injunction granted by the Hohoe High Court against the gazetting of the MP-elect for Hohoe constituency, that is John Peter Amewu. Now, a number of things transpired in court today, and we have here with us our court correspondent, Fred Tetejabano, to break it down for us. What essentially transpired today?
Yes, so when the case was called this morning, lawyers for the residents of Sao and the lead lawyer, Chachu Chikata, raised a preliminary objection. His objection was that he didn't want one of the empaneled justices here in this case to remain as part of the panel to hear this case. This judge is Justice Clemens Honyenuga. It was the case of Chachu Chikata that Clemens Honyenuga had a long-standing relationship and friendship with the MP-elect for Hohoe, John Peter Amewu. And because of this standing relationship and friendship, it could lead to some sort of bias and in him taking a decision or making a decision in this matter. The Supreme Court asked that what was his basis for this particular argument. And he said that they had evidence through people and the fact that Mr. John Peter Amewu himself had made comments initially talking about how close he was with Justice Honyenuga. The AG, or Deputy AG, who was representing the state, also objected to the objection by the lawyers for the residents of Sao. According to him, this particular claim or allegation had no basis. Hence, they didn't see why they should allow Justice Honyenuga to recuse himself or be removed as part of the panel. The panel decided to take a short break. They went into chambers. They discussed it. After about 30 minutes, they returned to court and made the argument that they were dismissing that particular objection raised by Chachu Chikata because according to them, it lacked merit and that he couldn't establish that relationship he was talking about. After this, the case actually moved on to the substantive matter, why the court sat today, which was the state asking for the injunction placed on John Peter Amewu by the High Court in Hohoe to be quashed. The state's lawyers, led by the Deputy AG Godfred Dame, made very interesting arguments. One of their arguments was that the procedure in which the lawyers for the residents of the South District went to court was wrong. According to him, they should have gone with a petition because this is an election matter, but rather went using the human rights application mode, which they believe that was wrong, procedurally wrong, because the laws, according to them, states that you should go through a petition if it has to do with election issues. He also raised the concerns of something they called human rights, whether they really even had any human rights concerns. He argued that he didn't believe that the residents of Sao had any human rights concern because, according to him, if you look at where they belong to the Sao district, which is in the Oti region. The Hohoe constituency is within the Volta region, and per the laws in our constitution, you can't have somebody, people belonging to a different region coming into another constituency which belongs to another region. Hence, they do not even have any grounding on coming for any human rights case. In his response to some of the concerns or the arguments raised by the AG, Chachuchi Kata, who represented the people of Sao, said that he believed that his client's rights to fundamental human rights had been breached, the rights to administrative justice have been breached, and the right to equality before the law has also been breached. He further stated that he believed that the EC in itself, the CI 12H, which they used to govern the elections, was unconstitutional, saying that this CI 128, once it was placed before Parliament, had to be published in the Gazette the day it was placed before Parliament. This was not done, according to Mr. Chikata. Hence, the entire CI was unconstitutional. After the court heard the two sides make their argument, the court set tomorrow, which is the 5th of January 2021, to give a ruling on this particular matter. So we are waiting for the court to give the ruling tomorrow at 12 p.m.
Right. Thank you so very much. There you have it, a very in-depth breakdown of what transpired at the Supreme Court today. About 20 or so members of parliament belonging to the minority side were expected to appear in response to charges by the state at Accra Circuit Court 11. But from what we are picking up, none of the MPs showed up. I'm being joined by our court correspondent, Sixtus Dong Ulu. What transpired today?
The state charged the members of parliament and a deputy general secretary of the NDC, Peter Boama Otukuno, with unlawful assembly and with failing to notify the police of a march. These are all in tenance with the Public Order Act. And so that hearing was supposed to happen today in this very court building, but it did not happen because they refused to turn up, or should we say they failed to turn up to this court hearing. Now, there's been no official explanation whatsoever to their inability to show up at the hearing today. What we have already picked up unofficially from our interaction with some of them is that the processes that are supposed to be satisfied before a member of parliament can be hauled before a court, those processes have still not been satisfied. You know that between now and 6th January, midnight of 6th January 2021, they remain members of parliament. And so before any of them can appear in court or be used as even a witness in the court case, the processes has to be followed through right to the Speaker of the House. The Speaker would have to release them before they can appear in court. We cannot say for sure that the state has not fulfilled these requirements. These are just charts that we have picked up from some of them as to why they did not show up today.
So since they did not show up, will there be any repercussions, and what is the way forward?
Ordinarily, if you fail to show up at your court hearing, you would be slapped with a contempt, likely. there likely also could be a warrant for your arrest, some other things, that measures that the state could take. But the case here is different. They are members of parliament, and there are processes that have to be followed through with. So until those processes are followed through with, then we can talk about the next steps. If it is also established that the processes have been followed through with, then the state may have to take the next steps.
Well, there you have it, 6-2 Olo, our court correspondent, explaining to us what transpired or what did not transpire in the Circuit Courts 11 today. The members of Parliament, along with the Deputy General Secretary of the NDC, Peter Otokuno, were supposed to have appeared in Parliament, but from all indications, the members of Parliament did not show up. Now, you're still watching the Citi Newsroom. We'll bring you more on this particular story.